Welcome, good afternoon. Welcome to Reason's first Freedom in Media event. I want to welcome everyone here in our Washington office, as well as those watching on Reason.tv, Reason.com, and Ustream. I am Stephen Titch. I am moderator, and I'm telecom and new media analyst for the Reason Foundation. We've titled today's presentation, Beyond the Seven Dirty Words, Protecting the Internet and New Media from Content Regulation. This, of course, is a reference to the seven dirty words that standards and practices said couldn't be said on TV, at least until TV ratings came along. And although content standards have become more flexible, there still remains among legislators and regulators a temptation to censor content. Techniques are a little more subtle. Nobody really goes after direct political or artistic expression. We hear terms like cultural sensitivity, decency, taste. We hear things like, well, a blogger isn't a real journalist, so therefore we need different regulations. But it's always been an easy target to go after new media, new technologies, whether it was rock and roll or jazz or comic books or television back in the day. But it's really sometimes disappointing to see some political leaders who should know better going this route. We had The Innocence of Muslims. It was not a very tasteful video. Nonetheless, the Obama administration felt necessary to blame the embassy, the consular attack in Benghazi on an internet video. We hear about video games being invited to be part of a dialogue on gun control. Bottom line, the First Amendment declares that government has no role in regulating or curtailing speech or expression, and the courts have made that clear. That extends to electronic media. What's more, because of the way the internet works, it offers far more opportunities for individuals to participate in the so-called marketplace of ideas. So we'll be looking at both those aspects today, but to start things off, I'd like to introduce our keynote speaker, Robert Corn-Revere. Partner in Davis Wright Tremaine, Mr. Corn-Revere has argued and won several high-profile First Amendment cases. His clients have ranged from major TV networks to the Comic Book Legal Defense Fund. Mr. Corn-Revere represented CBS in a successful challenge to the FCC's indecency finding and $550,000 penalty over that famous Janet Jackson wardrobe malfunction during the 2004 Super Bowl halftime show. Mr. Corn-Revere also represented CBS in a consolidated appeal challenging the FCC's application of broadcast indecency rules to so-called fleeting expletives and brief nudity from that show that some of you might remember, NYPD Blue. That case was only resolved last year, and the U.S. Supreme Court held that the FCC's decisions targeting these fleeting indecencies is unconstitutional. So indeed, Mr. Corn-Revere's legal acumen has been instrumental in beating back numerous government attempts to regulate or censor free speech and to determine what Americans see, hear, or read. He has shown the courts that laws such as the Communications Decency Act, Online Child Protection Act, and restrictions on the sale and rental of video games, however well-intentioned they might be, do not pass First Amendment tests. So it's my pleasure to give you a great friend of reason and a true hero in the battle for free speech, Robert Corn-Revere.
Thanks, Steve. Did you want me up here or?
However you feel.
Okay. Well, I appreciate being here. I always appreciate coming to Reason events, always talking about freedom and timely topics, and there's really nothing more timely than the interaction between the First Amendment and new communications technologies. And because it's timely, I thought I should start with a news item. As reported in Scientific American, July 6, 1901. An instance of the inescapable and inexplicable conservatism and arrogance of the Turkish customs authorities was recently evidenced by the prohibition of the importation of typewriters into the country. The reason advanced by the authorities for this step is that typewriting affords no clue to the author, and that therefore, in the event of seditious or opprobrious pamphlets or writings executed by the typewriter being circulated, it would be impossible to obtain any clue by which the operator of the machine could be traced. The same decree also applies to the mimeograph and other similar duplicating machines and mediums. Okay, 1901. It's official, I'm the oldest guy in the room. This has always been a perennial topic. I mentioned that not to make fun of repressive Middle Eastern governments. It's almost like a redundancy. And particularly when you think of the Arab Spring and the notion of the governments of Egypt and Syria, Tunisia, turning off the internet because people were organizing using social media. It seems like this would be just an antiquated application of the same phenomenon. But this isn't just something that pertains to that region of the world. It is part of the endless cycle of the tension between new technologies and authoritarian responses of trying to limit the power that they bring, to the individual. As a matter of fact, there's a real irony here in that technologies, while they expand human freedom, have always led to efforts to repress them. I've written in the past that censorship is the bastard child of technology, and in many ways, we've seen that cycle repeat itself many times over in history. For example, if you think of the advent of movable type and the Gutenberg press in 1450, there really weren't any organized attempts, no institutions of censorship before that time. Of course, there didn't need to be, because scribes were produced one by one, and they produced books singularly, and they were under the control of the hierarchy of the church, and you didn't need any kind of organized censorship bureau. It was only once you had the ability to mass produce books that you began to see efforts in Europe and in England to then begin to restrict the availability of the free press. And we saw this actually instituted through various mechanisms. There was the Court of the Star Chamber, instituted by Henry VIII, for example, which wasn't instituted specifically to suppress the press, and as a matter of fact, it had some laudable aspirations for why the Court of the Star Chamber was created. It was created because nobles and prominent people could escape justice in the regular civil courts, and so you needed some court that was under the control of the king that could then impose sanctions on people of higher status. The problem was it quickly became a method of suppression of any dissenters against the king, and particularly during the Reformation, which had been made possible through the mass dissemination of books, you then saw religious dissenters become the target of the Court of the Star Chamber. As a matter of fact, there was a decree in, I think, 1632 prohibiting the publication of news books because diplomats from Austria and I think Spain had complained that coverage in these books of the 30 Years' War was unfair. I suppose you could call it the first example of the fairness doctrine. But that was, again, the Court of the Star Chamber. We saw that eventually fade away, but it was replaced by England's licensing law, which required all publishers to be registered, all authors, all printers also to be registered, and that it gave the stationers' company a monopoly over the press with the ability to do search and seizure of publications that were considered to be offensive to the Crown, and basically to exert control. Now, again, the licensing law was the function of Parliament, and it wasn't that Parliament, in finally phasing out the Court of the Star Chamber, was in favor of press freedom. It's just that they preferred to exert control as opposed to directly control from the king. But eventually, all of these events and all of these efforts of control began to fade away, and yet they were prominent in the minds of the framers of the United States Constitution when that document was being written and the Bill of Rights was being formed. It was also prominent during the trial of John Peter Zenger in 1735, which addressed the issue of seditious libel. All of those things led to the creation of the First Amendment. They were foremost in the minds of the framers, and they adopted an amendment that Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, nor abridging the freedom of speech or of the press, or the right of people to peaceably assemble or to petition the government for redress of grievances. Those 45 words were adopted because the framers of the United States Constitution adopted this new communications technology, the ability to mass disseminate works at the time, as an integral part of the United States Constitution and an integral part of our political freedoms. Now, you would think that's the end of history, right? You have framers of the Constitution, they adopted a provision that's designed to make sure that government doesn't have control over the ability to mass produce works of expression, and that should be the end of it. Well, sadly it's not, because constitutional freedoms are not self-enforcing. It does require the courts to interpret and to ultimately enforce those rights. And the First Amendment really wasn't interpreted and applied by the courts until after the first quarter of the 20th century. It's only then that the Supreme Court began to look at some of these issues and to gradually begin defining and expanding freedoms under the First Amendment. The problem was that when it came to issues of technology, the courts were very reluctant to say that those hard-fought freedoms also applied to new technologies. We saw this cycle repeat itself on many different occasions. For example, it repeated itself with the issue of cinema. In 1915, the Supreme Court first addressed whether or not film was protected by the First Amendment, and the answer came back, well, of course not. State commissions were growing up to provide advanced censorship of films, and the court said that this is not a function of the press. This is merely an entertainment. It's commerce. And by the way, we think films are a little dangerous. You really shouldn't show pictures to everybody because it might give them the wrong ideas. It took another 37 years before the Supreme Court again addressed the issue of cinema and found that, yes, in fact, this technology was fully protected by the First Amendment. But it's, again, an issue that we confront again and again. And yet, we don't seem to learn the lesson that having been through that with one technology, we should extend the same protections to all. We're still fighting those issues when it comes to broadcasting, because broadcasters are licensed under the Communications Act of 1934, which, when you think about it, is really pretty ironic, because the First Amendment was a product of men who were rebelling against the very concept of press licensing. That was the history in England that was in their minds when they adopted the First Amendment. And so when we have this newer technology come along, the answer, according to Congress, when it adopted the law, was, well, why don't we license broadcasters? Now, wouldn't you think that obvious that that at least creates some tension with the First Amendment, which says Congress shall make no law abridging freedom of speech or of the press? Well, you might think so, but again, we've had to fight these battles each time the court has to reinterpret what the First Amendment means in the face of a new means of communication. Matter of fact, William Howard Taft, who was both president and then later Chief Justice of the Supreme Court, when he was on the court, said he wanted to put off for as long as possible the issue of what First Amendment rights apply to broadcasters because he considered radio akin to the occult. And so they managed to prevent that issue from actually being resolved for the longest time, and it's still not resolved. The first time the courts dealt with it was in the early 1930s. In 1932, the then Federal Radio Commission, the predecessor to the FCC, had revoked the license of a radio station for an inflammatory radio preacher. Imagine that. When a First Amendment challenge was brought, the Circuit Court reached essentially the same conclusion that the Supreme Court had with respect to film, saying that this is an instrument of commerce, and we don't think that the First Amendment prevents the FCC from revoking a broadcast license. It finally went to the Supreme Court in the 40s in the NBC case, looking at the constitutionality of what were called chain broadcasting rules or network rules. And that's where the court first began to apply the notion of frequency scarcity as a justification for treating broadcasting differently. Came back to the Supreme Court in 1969 in the Red Lion case, which upheld the fairness doctrine. And then last year there was a test of the FCC's broadcast indecency rules, in which case the court reached the right conclusion that the attempt to enforce the rules was unconstitutional as a violation of due process, but it stopped short of reaching the ultimate First Amendment question of whether or not broadcasting should have applied to it the same constitutional standard as other media. Again, the pattern repeats with every new technology. We saw it with cable television, for example, which the FCC initially decided it was going to treat simply as broadcasting, even though cable didn't rely on the electromagnetic spectrum in the same way as broadcasters, which is how you justified this different level of regulation. And so beginning in probably the 70s, when the FCC first wrote its cable television rules, until the 90s, when some of these concepts began to be tested, the court stopped short of trying to reach what level of First Amendment protection should apply to cable, even though it acknowledged in some of these cases that maybe the rules are a little different for this medium. Finally, in the year 2000, in a case that I argued, United States versus Playboy Entertainment Group, the court reached the conclusion that no, the same standard that applies to broadcasting does not apply to cable television, and as a result, it was going to apply a more robust First Amendment standard, even though some vestiges of that regulatory history continue even in the cable medium. Finally, with the internet, we see a genuine breakthrough, and this is true on a couple of levels. The internet is interesting for so many reasons. It has transformed the world. But in the regulatory world, it's interesting because it caught the government unawares. It came along, the internet, even though it had its origins in some government research. The World Wide Web was developed not as a result of any kind of government program, but it was there, and then the government had to later figure out what it was going to do with it, including to try and figure out what constitutional standard applied. Well, what would you imagine would be the first impulse of government to a technology of this kind of power and magnitude? Anybody? Of course, it's to regulate it. And of course, the regulatory structure that was adopted in the Telecommunications Act of 1996, or at least a portion of that act called the Communications Decency Act, was to impose broadcast-style indecency regulations on the internet. So that regime involving the 7 dirty words that Steve was talking about, that was going to be applied to the internet. Now, for anybody who uses the internet, and that would be, everybody, it's hard to even imagine what that world would look like if it were subject to the kind of FCC regulations that still today apply to broadcasting. But that case did ultimately go to the Supreme Court, and in 1997, the court ruled that there is no justification for treating the internet with any different level of First Amendment protection than you would for traditional media. That was a staggering, astounding conclusion. It is the first time in our history that in its first court test of a new technology, the court held that full First Amendment protections apply. And for that reason, it's really remarkable. But there are other reasons as well. I mean, for example, as I mentioned, the internet sort of developed in the absence of a government program rather than because of a government program. Can you even imagine what this technology would look like if it had been the product of an FCC notice and comment rulemaking proceeding? Well, we wouldn't have to imagine it because we wouldn't have an internet yet. We would still be waiting for the internet because any proceeding of that kind would take years. It would take decades to produce any kind of result. And when it did, do you think we would have the kind of free speech that we have on the internet today? Well, no. We would have a set of rules that look like the New York telephone directory. And, well, actually, do they still publish that? Are there still telephone directories? I guess there are, but nobody really uses them as much anymore because we have these great new technologies that democratize information and make information universally available. Because of that, we have achieved, through the absence of government regulation, more in the nature of public interest benefits than were ever produced by decades of regulation applied to other electronic media. I was at an event probably 20 years ago where someone was talking about the benefits of cable television regulations, including the regulations that require local cable operators to provide public access channels so that individuals would have the ability to speak to their community through these channels that are set aside for public speech. And he said, you know, probably the best show I ever saw was on a public access channel, and I doubt if anyone else really wanted to watch it, but they were covering on that channel my daughter's ballet recital. And so people had a chance to see it on TV. And I turned to him and I said, so I guess this happened before the advent of camcorders, right? I mean, even then, if someone wanted to watch their daughter's ballet recital on television, they could do a camcorder. You didn't need this regulatory apparatus to regulate the entire community and to basically confiscate channels for private use, or in this case, public use, but with a private audience of one, so that you could achieve this result. Those regulations are still in place and still put a drag on cable operators around the nation in their areas of franchise. And yet with the internet, we have through YouTube, through any number of channels, the ability to speak to a global audience without the need for this kind of regulatory apparatus. Once again, by the absence of government oversight, we have seen the development of public interest benefits that couldn't have been imagined by government regulators. The problem that we face going forward is that the lessons that are seemingly obvious and in front of us every day are really lost whenever we confront a new problem. That is, the next time we see an issue come up involving the internet, will we instinctively, or will policymakers instinctively think, well, we gained all these benefits through not applying regulation in the past, maybe we should do that going forward. The problem is when new issues come along, quite often the initial impulse is to find a way for a mandatory solution to try and solve the problem for everybody. We see this time and time again with various internet issues. For example, there's the issue of internet governance. I use the word governance because it does imply a regulatory solution. And in the 90s, when the Supreme Court decided the Reno case, which held that the internet was fully protected by the First Amendment, the administration at the time, the Clinton administration, was fully aware that if you tried to impose a governmental solution after it had lost the Reno case, that you might lose the benefits of the internet. And so when it came to issues of managing domain names, for example, they proposed having a private solution in ICANN in managing domain names. That solution is still in place today, imperfect as it is, but it is there. But because there are problems that come up with ICANN, you have people calling for not internet management or domain name management, but internet governance. That is, having governmental institutions through a treaty, through something like the UN, impose regulations over the internet. It's a truly frightening prospect. We see this issue come up with other technologies, not just internet technologies as well. Pete Tucker is here, and he'll be speaking to you from the panel. And the first time I met Pete, he had just gotten out of jail. He'll probably tell you a little bit more about that. But because he had had the temerity to take a photograph at a public meeting. Now, in any setting where you have protections for the press, that's truly frightening. But because technology has extended the ability of every individual to be carrying a camera, and not just a camera, but a video recorder with them at pretty much all times, if that technology is not respected and protected by the constitutional protections and by government policies, then you stand the risk of turning every individual into a criminal. We're still looking at whether or not this technology is going to be protected by the courts, and so far the decisions that we've seen have been very promising. Again, as each new development occurs, we have to fight that battle over and over again. We see this as well with the ability to carry all of your personal life on a laptop computer or a pad when you travel around. But yet one of the implications of that is that when you cross an international border, the Fourth Amendment protection against search and seizure doesn't really apply. And that is, if border agents want to open your computer, look through the files, they can do so. And decisions up to this point have said they don't even have to have reasonable suspicion to be able to do that, let alone a search warrant. Now again, courts in the Ninth Circuit just last week issued an opinion that suggested that there is a growing sensitivity to these issues that technology bring. But as I've said before, it is a lesson that we need to learn over and over again. So I'm hoping that events like this will help sensitize you all to these issues and bring insights and talk about some of the issues that are coming up. And hopefully, as we move forward, these lessons ultimately will sink in. Thank you.
Thank you. Excuse me. Thank you, Bob. I'm not sure if we have Pete Tucker is going to join us now, and I'd like to invite Bob to participate as well. We are expected to have a second panelist who is not here yet, Chuck Stewart from Smack Time Entertainment. But let me introduce Pete Tucker. You already got a brief introduction from Bob. Pete Tucker is the founder and publisher of thefightback.org. This is an online publication that covers policy in Washington, D.C. from more or less the street level. It looks at how rulemakings, policymakings, laws affect poor, disenfranchised, people trying to simply get by. As Bob said, last year Pete was covering a public meeting of the Washington, D.C. Taxi Commission. He was photographing. He was alongside a Reason reporter, a New York-based Reason reporter, Jim Epstein. The chairman of the commission asked them both to stop photographing and recording. They did not, and they were arrested. Mr. Corn-Revere helped us out much on that. So I'd like to invite Pete to come up to talk about some of his experiences as an online journalist and an online publisher. Bob, if you'd care to join us on stage. I'd like to start with Pete, maybe starting really to address some of the public interest side of what the internet now creates that Bob was mentioning. What have you been able to do through the Fight Back that would not have been possible, say, as little as 5 years ago?
Well, thank you so much for the introduction. Good afternoon, and thank you to Reason and for including me. And let me say what a privilege it is to participate in a discussion that highlights Bob Corn-Revere. I actually knew of his work before I met him. As was mentioned, I was arrested I was actually National Park Police headquarters. The Taxi Cab Commission was holding its meeting after several hours in jail. I was being let out, and I think Bob had showed up. He was representing Jim Epstein, the Reason reporter, who was arrested for filming my arrest. And I was getting back my shoes and my belt. They take that so you don't kill yourself. I was upset, but I wasn't that upset. And so as I'm getting this stuff back, the officer, she's handing back my phone too, and a head guy walks in, and he says, "All the phones go back." And so she reached to take my phone back. And he said, no, they go. And I think it was at that point that Bob had showed up, I'm guessing, the timing, because it was just to have a high-up person come in and make a quick, abrupt decision. And he let him know about the First Amendment, and not only did I get my phone back, but the other reporter who had the whole thing on video got his phone back. And the difference that made was that upon arrest, the taxi cab commission put out that I was disruptive and all this stuff. And when the video went out, it just put all that to shame. So for that and many other reasons, it's a privilege to get to have a discussion with Bob. And yeah, the internet is, as everyone here knows, it is an amazing tool. And as Bob has pointed out, it's not the first time in American history that we have a new media with which to reach out to people. And every time that happens, there is a push to clamp down on it. It is, one of the scary things right now, I think, in addition to some of the concerns that Bob raised, is these are some of the largest corporations on earth that are looking to do what they've done historically in this country, which is you have periods of openings, whether it be the newspaper, which was part of the reason that this country fomented a successful revolution, and one of the reasons why that First Amendment is enshrined the way it is. And from the radio to the television and now the internet, anytime these new openings come in, there is a chance for individuals and small groups of people to reach large numbers of people. And then it seems to clamp down pretty quickly. There's an amazing book out recently called News for All the People by Juan Gonzalez and Joe Torres. Juan Gonzalez, co-host of Democracy Now!, and Joe Torres is with Free Press. And it documents how, first of all, how excluded minorities are in the history of this country when it comes to the media, but also how these openings are short-lived. And this ability right now to reach large numbers of people that I think probably looking at the age of us here in this room, we all take for granted, is nothing to be taken for granted at all if you look at U.S. history. And the attacks, whether it be Sista, the big companies, and as well as the government, it is going to take a serious fight, as it did a year ago with Sista, to protect this privilege to reach people, which we all take for granted. And yeah, it has, through the website and Twitter and Facebook, you're able to bring the voices of the street to large numbers of people, which is an incredible privilege and opportunity, and one that I think we all need to do a lot to protect.
I'll ask both of you, what do you see as really the greatest threats right now, or the things that worry you? Again, there doesn't seem to be that much of a direct attempt to say, let's regulate websites, but we see attempts to regulate comments, to hold website publishers liable for what might be posted on their site, or third-party deputization. You've got to report something. Those are some examples. There might be others. But what are some of the regulatory proposals that don't sound like censorship, yet the net result may be suppression of content?
You go. Yeah. You want to go first?
Okay. The danger is that there's always a good reason to regulate. Regulation isn't proposed by people bent on some evil plan of control. Well, sometimes it is, but usually not. I mean, usually regulation is proposed for very good and sufficient reasons. Even if you go back to broadcast regulations and talk about the fairness doctrine, the notion behind it was that it was just meant to codify good journalistic practice, which I'm all for good journalistic practice, but when it's done by government mandate, not such a good idea. And so you'll see all kinds of regulations being proposed that have useful and beneficial purposes, but that are ultimately either unworkable or had some flaw in the design in the first place. Take, for example, network neutrality, which is a principle. Actually, that term is such a nice PR term. It's hard to know exactly what it means. It kind of means many things to many different people. But the notion behind it is The network should be free and open to all, and so we should regulate in the name of making sure it's free and open to all. The difficulty with doing that is that you have to define terms. You need to decide who's going to be in control of the network. When you have dispersal of the ability to control, even when it's to major corporations, that at least isn't centralizing it in one authority that's going to make one rule, one size fits all. That's one of the difficulties. I testified at an FCC hearing on this once, and I found it necessary to remind people at the hearing that you have to look at the history of government efforts to regulate in this area, where, of course, the first impulse is to regulate content. But even if you look at efforts of the FCC to create regulations to design open networks, and they've been through this various times with a proposal around the turn of the century called video dial tone, the turn of the last century, not 1900 again, or open video systems, which were designed as part of the Telecommunications Act of 1996. They were all spectacular failures. They were regulations in search of a market rather than a market that had developed out there that needed some sort of regulatory touches. You see this as well with issues involving the domain name system, or take, for example, Senator Lieberman's proposal for an internet kill switch, right? Because, of course, China had one, so we should have one too. You know, as I say, there are always good and sufficient reasons to regulate. I mean, that was being proposed in the name of cybersecurity, and particularly in light of news events now, who could be against cybersecurity? But you have to be careful about, once you open the door, what walks through. And usually I've found that with these kinds of technologies, once you open the door to some kind of government control, that the next thing that follows isn't so beneficial and helpful.
And I would just add to that I think well, first of all, the internet is an amazing tool, but it already has cut off so many people. I mean, the cost of our phones is such that a large part of this country finds it, first of all, a lot of people can't even get broadband in this country, even if they wanted to. But a professor, I was met a professor from Kansas. He's originally from South Korea. And he would take some students from South Korea, and they would come to, I think it was the University of Pittsburgh in Kansas, so they thought maybe they're coming to an eastern U.S. city. And they would come to, and South Korea's got amazing broadband. So they would come to the middle of Kansas, and they would say, South Korea is more America than Kansas is. So people are cut off that way. And then people are cut off because it's just expensive to pay these monthly bills. Cuts off a lot of people as it is. And a fear that I have going forward is that, well, with network neutrality, the fight back without resources loads at the same speed as NBC. But while yes, I think it is concerning that you don't want, you know, the government, and it can do overreach when it comes to things and controlling, but the same is true with some of the largest corporations on earth. And if they control the landscape and they can charge one rate for your website to load at a good speed, and for those of people who don't have enough money, you get it loaded at a slower rate, essentially you're, again, cutting off a lot of people. And so I think that is a very serious concern. And that follows the pattern of what's happened in this country. New media comes along and the big boys come in. And so I find that to be an additional concern. Who gets access already? As I said, a lot of people are cut off. And then if you have a two-tiered system within that, I think that has a potential to cut off a lot more.
But let me pursue that a little bit at your level. Do you have trouble being recognized as a legitimate journalist, as a counterpart at the Washington Post or the Times, or even one of the community newspapers that are usually weekly or biweekly? Obviously, there was a trouble at the D.C. Commission understanding that Is that changing, or is that an issue? And as part of that, is there a difference between a blogger and an online journalist?
It was very, when I was arrested, I was interested to see how the media covered it. I was fortunate they said reporters. The Washington Post editorial said 2 reporters were arrested. And it could have gone either way, so I was very appreciative because that's how I view myself. And I think it's very important to be accurate. You know, you want to strive to be accurate, and I do. And then beyond that, I mean, the difference between a blogger and online journalism, you just try and be accurate as best you can. If you make a mistake, you know, you live up to that and you note it. But yeah, you just try and put yourself out there. And since I'm covering activism, I'm usually going to where other reporters are not. So you don't have to really convince someone who's out protesting and no other media is paying attention to them, look, I really am a reporter, I swear. You got a microphone, they'll talk. People want to get their message out. Many people are silenced by a corporate media that it doesn't have enough reporters on the street. And that's why I became a reporter, because as an activist, I saw time and again that issues that I was working on and that others were working on did not have access to the media. And when you did, it was fleeting. If you did, it was very fleeting and dismissive. There are people, they're angry. Okay, on to the weather. And that's not enough. You get the sound bite, but you don't get the whole meal. And so you don't have to convince people out protesting, you know, I swear I'm a journalist, you know, they'll talk.
I'm thinking more in official circles. Like when you go for that after you've talked to the people on the street, you go for that comment at the official level or at the governing level.
Mostly I'm in D.C. and D.C. folks know me. I suppose that will definitely, if I tried to go to the Hill and cover stuff there, that would be an ongoing issue that I'd have to wrestle with.
But go ahead.
Well, I was just going to say, this is one of the issues that we confront in the law because of changes in technology, because everybody has the tools available that they can potentially speak to a global audience or even a microscopic regional audience, depending on how the message is targeted. And because of that, it has put some significant tensions on the way in which officials deal with people. Are they journalists? Are they members of the press? Are they just somebody out there with a gripe? And it may affect how they treat them. And because of that, there is quite a bit of uncertainty. You know, the question, do bloggers qualify as journalists? Well, if they're performing journalism, then of course, yes. But it's kind of like the old Smothers Brothers song by the Streets of Laredo, where the line is, you can tell by my outfit that I'm a cowboy. If you get an outfit, you can be a cowboy too. Well, just because you've got a reporter's pad or a microphone doesn't make you a reporter, doesn't make you a journalist. But the First Amendment protects you nonetheless. You have the same protections under the First Amendment, whether or not you are officially recognized as a journalist. And this we see come up in various ways. One is getting press credentials, right? I mean, different cities will credential people as reporters, but they have to go through a process for that. And whether or not they recognize them can make the difference on whether or not they get to go on the other side of police lines. And then you see the issue come up in the very kinds of cases in which Pete was caught up in, the arrest of people who are reporting or taking photographs. Because everyone has the technology with them now pretty much at all times, the question has come up in these cases whether or not individuals who are not members of the press have the same First Amendment protections. And fortunately, so far, the courts have reached the uniform conclusion that you have the same level of First Amendment protection when you're out there taking photographs of people doing their official duties, whether or not you're officially recognized as a member of the press or not. And yet, the questions keep coming back in different forms. There was a decision in the Virginia Supreme Court just last week on whether or not an attorney could be sanctioned for his blogging activities. And it was considered, the Supreme Court of the state said, yes, it could be because it was a blog, and therefore this was commercial speech, because even though he was reporting on legal matters, the blog was connected to his law firm website, and therefore that made it commercial, even though his activities were then talking about legal developments generally, as well as on the cases that he wrote on. So again, these questions are going to recur in various different forms, and it's particularly significant that we keep reminding courts that the First Amendment should apply regardless of the way in which you perform your expressive acts.
Do we have questions from the audience at this point? Okay, we'll take the question from the audience and then go from Twitter.
I wondered if the panel could speak to where intellectual property laws intersect with content creation.
Right, the question was if you could address where intellectual property laws intersect here.
Bob Corn-Revere.
Where do they intersect? Everywhere. I mean, the internet is a huge copying machine, right? And so, you know, the ability to use another person's intellectual property is seemingly endless. That has led to legislative reactions for whether or not websites can be responsible because they happen to post information that someone, a third party, has posted on them. And so the Digital Millennium Copyright Act provides a whole notice and takedown regime for what the third-party website is supposed to do to avoid getting in trouble themselves for assisting in copyright infringement. There's the whole question of trademark and what to do about domain names. And again, ICANN is in the process of permitting sort of a .anything regime where you can have sort of, for all those people who applied for these things, sort of an endless number of top-level domains. Now, the difficulty there for trademark holders, of course, is that someone may want to capitalize on your popular and well-established trademark, and so as a result, they'll create a website using, you know, Exxon dot whatever, right? And so that is a matter that's very concerning to trademark holders, and so you have to find ways of trying to balance these rights and to do it in a way that doesn't go completely overboard, which actually gets back to one of your earlier questions about what do you do about third-party intermediaries, the people who simply allow stuff to be posted even though they aren't responsible for either infringing someone's copyright or posting something that's defamatory or something else. Here's where the U.S. Congress actually blundered into one of the best internet laws ever, and that's Section 230 of the Communications Decency Act, which was adopted largely in part on purpose and in part by accident. And it happened when the legislation that became the Communications Decency Act was being debated in 1995. And some people thought that the proposal of this heavy-handed FCC-style regulation went too far. And so then Representative Cox said, well, why don't we do something else? We'll adopt this Good Samaritan provision that says that internet intermediaries will not be held responsible for the content that other people post, but they'll also have the ability to take stuff down if they consider it to be offensive or infringing or something like that. And so that was the origin of the law that doesn't hold, say, Google responsible for the fact that someone may find infringing material when they do a search because they were just the intermediary that allowed someone to find it. They didn't post it themselves. That has done as much or more to expand internet freedom as anything else. And yet it was something that was adopted really, not exactly accidentally, but that wasn't the intent when it was adopted. Congress, of course, being Congress, looked at these two different proposals and said, what the hell, let's adopt both. And so that was how that came about.
And I don't have anything to add to that. I do want to get in the queue. I have a question for Bob as well.
What's our question from Twitter?
This one is from the Abridged Zach on Twitter. His question is, what would be a better way than net neutrality to address concerns about ISPs restricting data transmission? And a reminder, you can ask questions on Twitter, hashtag Freedom in Media, or on Facebook or Reason.com.
Well, frankly, I think competition is the best way to deal with that. I mean, the fact that if there are internet companies that adopt restrictive policies, there is more ability to open alternatives in the online environment than there ever had been in the history of electronic media. Actually, I had this conversation with someone last week where they were lamenting the fact that they thought Facebook policies were too restrictive of an idea that they had to promote sexual freedom. Now, I'm all in favor of sexual freedom. I like sexual freedom. But whether or not you can force Facebook to change their editorial policies because you think that they are somehow a public town square is really another question. So again, I think the regulatory solution to try to adopt federal oversight of networks is really a mistake.
And that actually feeds into the question I wanted to get Bob's thoughts on, which is this CISPA. I'm trying to read up on it, and I think you know an awful lot more about it. But part of it is you have a lot of data being gathered from consumers is a major part of it spoken to there. Let me just offer my comments, and then if you can comment on that. I think that it's critically important that we do have network neutrality because I think that functionally there's only, I mean, how do I know, what company your phone is? There's just very few companies that we have to go through. And so I think there needs to be a basic set of rules. Otherwise, we're going to, functionally we already have the infrastructure of this country is AT&T, Verizon, T-Mobile, basically, have we covered it? Sprint. So it's not like, there is theoretically, what was that?
I said Virgin Mobile, a lot of companies.
But probably the ones we just named, probably 90% of the country. And so theoretically a startup can come in, but practically that's not the case. So I would say to the question on Twitter that net neutrality to me would probably be the best way. But as I said, I've been trying to read up on CISPA, and I was wondering your thoughts on it and the concerns. You have telecoms that have worked with the government, and they have huge amounts of our personal data being stored, and if you have concerns about that. And if you could explain it too, because I don't claim to be an expert.
Well, I don't claim to be an expert on CISPA either. This is the current proposal to address cybersecurity issues, and the heart of it would allow U.S. security agencies access to information that is collected by major carriers to address cybersecurity concerns. Again, very controversial, and I think that these kinds of regulations always have the danger of going too far in allowing access to that kind of information, just as, when you look at previous efforts to control, the last major rewrite of our electronic surveillance laws, the Electronic Communications Privacy Act of 1986, was again an effort to strike the same kind of balance for what network carriers, what kind of information they had to provide, or what kind of process the government had to go through before it could get access to information and install wiretaps and things like that. I guess CALEA, which the Communications, I can't remember what the acronym stands for, but Law Enforcement Assistance Act, which was adopted in the mid-90s, which was designed as networks started becoming digital to require them to provide some measure of ability for the government to continue to conduct warranted, or when it was authorized, electronic surveillance, despite the fact that the technology had changed. But anytime we go through these changes in the law to keep up with technology, you have to be particularly vigilant that Congress doesn't go too far in allowing the government access to too much private information. Because obviously when you're doing business with a company or with anybody, they're going to have information, and sometimes that information is stored on their systems that is confidential and should be protected.
I'll take a question in the back. I appreciate Pete coming. You're speaking. You're in the lion's den talking about net neutrality, and I appreciate your defense of it. I'd like to keep the discussion more on the internet content regulation. I realize net neutrality has a dimension of that, but I think more or less our panel will be more in agreement as we head toward that.
If I could just say one thing about that, because people talk about internet freedom and network neutrality and content regulation all sort of in the same vein. But network neutrality is not designed really to protect internet content. I mean, some people will try and frame it at that, but proponents of network neutrality have a very difficult time coming up with examples of people actually restricting content. They're really more concerned about bandwidth controls. And there it's a question of whether or not the builders and the companies that run networks have the ability to do bandwidth management to determine whether or not the network can be used by all the users. And one way of regulating that is by price. And you know, other by corporate policies that they adopt. So the debate over network neutrality really focuses on that, but even though that's the focus, it will sometimes be justified as saying that these companies are going to censor us, and that's really not the issue.
Question about, building on the gentleman's question about intellectual property and content regulation. So I'm a DJ, and my current understanding of the copyright law around music is that a large majority of DJs frequently violate copyright in mixing two songs together without the explicit permission of the copyright holder. So I was curious to get your thoughts on how copyright, particularly in the artistic area, has an effect on restricting speech and creative expression.
This is a question. Our questioner is a DJ, noting that DJs often mix two songs together, doing so without permission of the copyright holders. This is the question: is this a copyright issue because it does involve the creation of something new, right?
Yeah, and you know, obviously it's a copyright issue where you're taking the intellectual property that belongs to one person and then creating some sort of new expression, new commercialized product. But it's one that the courts have dealt with really over time. First, to preface this, I'm not an intellectual property expert, and also I have no idea what the practice of most DJs might be. Again, oldest guy in the room. But that being said, the Supreme Court has addressed this, for example, in the 90s in the Two Live Crew case, where Two Live Crew had a parody of the song Pretty Woman. And the question was whether or not this was an infringement. And there the court looked at the use and saw that it was a transformative use of this existing intellectual property. That is, what they borrowed from the original work was enough so that they could create something new. And the question is, again, how much are you really just copying and using and profiting from somebody else's work, and how much are you creating something new?
I remember Two Live Crew.
From Twitter?
Yes, this one is from Facebook. Brad Hobbs asks, could you guys touch on the impact of the newly passed law in Great Britain requiring publisher registration? As the internet is available in the UK, what will be the impact with Britain's loosey-goosey libel shopping laws?
If I were as loaded as that question, I'd be ashamed to be here. I really can't speak to the law in Great Britain, I would be interested in hearing more about that. Generally, the law in Britain is much more favorable to libel plaintiffs, that if you are sued for libel, you have to then demonstrate that what you wrote was true, as opposed to the presumption in this country that says that if you are, depending on the nature of the libel plaintiff, whether it's a public official, a public figure, a private citizen, they still have the burden of proof to show that what you wrote was false and knowingly false, with differing levels of protection and different presumptions. With respect to this question about registering publishers, this is an issue that has become controversial because of the new technologies, and one that, again, goes back to the early British licensing laws, where you had to register the publisher, identify the author, identify the printer, all of those things. And those were the kinds of issues that were foremost in the minds of the framers of the Constitution. It's one of the reasons why the Federalist Papers were written under pseudonyms, because the framers of the Constitution, the people who devised this system, these geniuses who devised a system that could be run by idiots, decided that you needed to have those kinds of protections even for anonymous speech. And as a result, court decisions over the last 50 years have recognized that in the United States, you do have a right to speak anonymously. But as new technologies come along and as people get upset that you'll have anonymous bloggers, you'll have people posting comments, scurrilous, horrible things about people online, and they'll do it without attribution, they'll do it without identifying themselves, that we need a new law. But the fact is, the reasons that gave birth to the First Amendment and that led to the court decisions with previous technologies about anonymous speech apply equally to online speech, and the dangers of requiring people to identify themselves either as publishers or as posters of comments, those impulses are extremely damaging to, I think, our traditions of free expression. I faced this issue in the late 90s when I helped with a case involving cryptographic software and the source code for cryptographic software, and whether or not the source code that could allow you to encrypt your words was protected speech. And there you're kind of 2 steps removed from speaking out in the open, both because we're talking about being able to encrypt speech, so it's sort of private speech, but also because we're talking about not just the speech itself, but we're talking about the technology used and the source code for the technology used to make that speech confidential. Ultimately, we did get a court to say that that source code was protected by the First Amendment, and that because it fed into this tradition of being able to speak anonymously in the United States. So any impulse, whether it's in this country or in Britain, I think would be incredibly damaging to our traditions of free expression.
Question in the back?
So my question is, if all these regulations on the internet that you're worried about, if they would take effect, what would the internet, to the consumer, to regular people who use the internet every day, what would it be different about it? What would it sort of actually look like? Or, what's your dystopian vision?
It's a general question, but the question is essentially, what would a content-regulated internet look like work for the consumer?
Are you directing it? Do you want to go first?
Ever been to China? Actually, if you look around the world, you'll find a whole variety of different ways of exerting control, some more successful than others, over content online. In this country, we're just so used to freedom. We're so used to a free internet. It's like breathing the air for us, so that we really don't think about what it would be like if somebody restricted it. And unfortunately, you still have examples where people will try to, and that's why guys like me have a job. But in other countries, there are various mechanisms used. In China, they have the Great Firewall, of course, where they try to limit access by their citizens to all kinds of information. Try and go on and the Chinese equivalent of Google and search the term Tiananmen Square, for example. Saudi Arabia uses much the same kind of technology, where they basically censor everything coming into the country. Others have more draconian ways of applying content regulations, so that, if you post something that is considered to be insulting to the sovereign, you can be prosecuted for that. I was involved in a case involving Yahoo. Actually, this was the U.S. service, but Yahoo France was complying with their basically hate speech laws and anti-Nazi memorabilia regulations, because in Europe there's a very strong tradition now of post-World War II of not permitting anything that is in any way considered to be apologetic for the Nazi regime or anything like that. And so even posting a copy of Mein Kampf online can be considered a violation of that law. But Yahoo in the United States, through its auction site, had availability. People were marketing, third parties again, copies of various kinds of World War II and Nazi memorabilia. And so a suit was brought in Paris against Yahoo in the United States because it could be, or at least brought in France concerning the US version of Yahoo because it could be accessed over there. And there was a judgment issued in France saying that Yahoo had to pay a fine of, I forget how much, but it kept adding up day after day that they were still in violation. Now, ultimately, that couldn't be collected, and the courts in this country ruled that because they wouldn't be able to come here and enforce it because of the First Amendment, that you couldn't file a case in this country to block a collection that wasn't going to happen. But in France, you know, you can't have access to that material. Or take any of the sort of content concerns that any other government might want to express, whether it's anti-hate speech or whether it's Sharia law or whether it's, you know, not saying anything bad about the Vatican in Italy. Those regulations can be enforced there, but not here.
You asked what a dystopian vision of the internet would be. And I think Bob mentioned you can't insult the Sultan. And that is very scary. And I would just add that the Sultan can be, you know, the powers that be. And I would only think, and first of all, it's just a privilege because, you know, Bob is such a wealth of information and he's been on the front lines of this First Amendment fight for so long. The thing that, we're at the 10th anniversary of the Iraq War. And the reason we were in Iraq was because, yes, the government put out lies, but the media consolidated, ran with those lies. And so there is a concern that when power gets consolidated and the information is distributed through a few, that we end up with policies that are very damaging. And so I do think that a network neutrality, I know but it ties up here, that is regulated such that it's not a few that can reach the homes, the cars, the living rooms of this country, but it is a diverse source, allows for multiplicity of voices. So I would be concerned, my dystopia would be an internet that is, the government's taking all our information and capturing it, and the big companies are charging much higher to be able to reach at significant speeds, and thereby they get to reach the people of this country, just like they do on television. And I think that's very dangerous for, as we see at the 10th anniversary of the Iraq War, and how much treasure and lives have been lost because we had a media that did not ask the tough questions. Independent media did. Independent media did. But independent media doesn't have the reach. They're on the public access channels, but they don't have the access to the cars and living rooms throughout this country. And so my dystopian version would be one that mimics the current set of media that we have, and that my utopian version would be one that there's more space for independent media, for differing voices and different perspectives, that more space for that. And I think if that was the case, I think we'd have very different domestic and foreign policies in this country.
Actually, just to pick up on that, because I think we start at the same place when you're talking about the 10th anniversary of the Iraq War. I think there's no question but that the institutional media fell down on the job in questioning and being skeptical about the justifications for the war. And for that reason, the American people, for whatever reason, whether it's by the media or their own inclinations, also were insufficiently skeptical about the justifications for that war. Now, that being said, there were some major newspapers, the Cox chain, for example, that did some really good work. There are others that did as well. There were other independent voices, and this was in the internet age when this happened. So it wasn't that people didn't have access to sources of information, but for whatever cultural reason, we as a nation didn't ask the questions, and we ended up with some fairly disastrous policies as a result. But that being said, I don't know that that leads to the policy conclusions that you reach. And again, to draw on history, we've kind of seen this happen in the past. It's interesting that people talk about the heyday of FCC regulation as when you have all of this great public interest regulation, you have a fairness doctrine, you have regulations, strict regulations of ownership, you have limited licensing periods. And that's the great period in which we're promoting the public interest. And when the FCC stood for something, we will hear some people say. But of course, that was a time in which we had 3 broadcast networks. We had nightly news that lasted for a half hour, we had a complete inability of individual citizens to communicate. And that was because of basically a regulatory structure that more or less created and enforced that system of limited access. If you go back to the early days of radio, the early 20s, for example, before the Radio Act was passed in 1927, you saw a period of experimentation and a period of optimism that was very much like the internet period that we saw in the 1990s when people were discovering the World Wide Web. You had people tinkering in their garages and people creating crystal sets and people going on the air overnight, which did lead to interference. And you had people developing solutions to that. For example, developing better radio receivers for one thing, instead of crystal sets where you had to have a safecracker's touch to get any kind of radio signal. And you also saw some courts beginning to develop systems of property rights for people who had homesteaded different frequencies. But nonetheless, Congress stepped in 1927 and put a stop to at least the legal developments in that area, and created a system that essentially enforced the notion of having essentially three major providers and developed a system of controls that were, I think, unprecedented in the world of mass disseminated press, at least unprecedented since England in the 16th and 17th century. The interesting thing about that, the very first act of the Federal Radio Commission in 1928 was to throw off the air hundreds of radio experimenters, people who'd been out there sort of creating the medium and instead enforced strictly just who the licensed broadcasters were going to be. And as a result, we grew up with a limited number of radio networks and then a limited number of broadcast networks, promising efforts to have upstarts come and challenge that structure fell by the wayside, largely because they could rely on federal regulations to prevent them from getting involved. It wasn't until the 1980s that Fox came along, and for whatever you feel about that network or Fox News or anything else, the history is that there had been three networks throughout the past. It looked like that was going to be the fate going forward. And it was only because you had an upstart challenging the federal regulations that existed at the time that you were able to create then a fourth network. And then, of course, cable came along. Well, cable was already in development, but cable networks were coming along as well, creating much more choice and diversity, largely because those networks were free of the kinds of universal content regulations that existed for broadcasting. So even where you can start by diagnosing a given problem and thinking that the solution to that is that we need someone to go in and lay down the law, our history is that when someone does, you have almost exactly the opposite result of what you would hope would come about.
But if I can follow with that in some cases is the result of often a maturing industry working with government, in some cases doing exactly what they can to create barriers to entry from upstarts. Is there a concern, and the government can tend to do this, it did this with TV, it did this with movies, kind of intimidating an industry into adopting some sort of quote-unquote voluntary standards. I'm thinking of the movie rating systems, which was developed by Jack Valenti, who was a Johnson administration, a part of the Johnson administration. Everybody went along with it, the government, the studios, the exhibitors, because they wanted the movies to be a place where families could go to, a friendly place. But some say that it has really inhibited independent filmmakers. Could there be a point where the government approaches or begins to pressure Google, which owns YouTube? Let's have some kind of standard here. We won't impose it, but we will strongly suggest you create it. Is this pattern likely to repeat itself, or is it just too endemic right now with YouTube and other video sources that you really can't get that level of granularity or ratings or standards and practices into the internet, especially entertainment?
I look forward to hearing Bob's thoughts. I would say that's already happened at the back end of the sites, that you have kind of coercion where these companies basically have to go along to give up their information of their customers. So maybe at the front end, I'm not so sure, but the back end of the site and all the information that's being collected, you know, I don't think the courts have I think that I don't think the courts have clearly said this is, you can't transmit this. In fact, they've been working closely to do just that.
Well, just to start with the issue of what kind of information companies are giving over, the issue isn't whether or not the companies can or should give information under the right circumstances. The issue has always been what process is required for that, just as, you know, the government can search your home if they have a search warrant. They can wiretap your phone if they have a search warrant. It is the process that protects our constitutional liberties. And when you're dealing with third-party intermediaries, the companies that provide those services, then the question is what kind of process is required. Since 1967, a key Supreme Court decision at that time, it did require a search warrant to have a wiretap. Law was then codified in 1968 and 1986 that applied to that as well. I would think after, you know, after 9/11, when the Patriot Act was passed, cobbled together, oddly enough, from proposals I had testified against during the Clinton administration, the Patriot Act loosened those standards and made it more possible for information to be shared. And so again, we get back to the question, and CISPA is the same debate over what kind of process is required before telecommunications companies and network managers are required to share that information, because short of that kind of requirement, they're not in the business for giving up your personal information. But the question that you started with, which goes to government and private companies collaborating, I would take issue with the example of the movie rating system, in part because MPAA is a client, and and I'm just saying that in the name, so for full disclosure purposes, but also because you have to consider the alternative. If you go back to the early days of film and the Hayes Office that was adopted by the Film Production Code, that was a much heavier type of censorship than ever existed. You had all of these pre-code Hollywood films that are classics that nobody had really heard about since, because things clamped down. And there it was, sort of very strongly influenced by government. And it was a time before courts even recognized First Amendment protections for films. And so the industry stepped up to sort of forestall government action, and I think all would acknowledge that it went way too far. But things began to change in the 1960s, and not only had courts begun to strike down these various local state censorship laws, but Hollywood was also trying to change with the changing legal climate and also the cultural changes that were happening in the 60s. And so it was then that the MPAA rating system, the production that you mentioned, Jack Valenti was instrumental in helping to create, did create a system so that basically it's so that people can be informed going into a film what they might be likely to expect. Is it perfect? Well, no rating system is perfect. But as a private editorial judgment for what kind of film to expect, it's not a bad guideline. They routinely get about 80 to 85% consumer approval ratings for whether or not people think that the ratings are useful. The question of whether or not ratings can be used by government is something very different, though. Anytime you involve government in either implementing these or enforcing ratings decisions, then disasters occur. And as a matter of fact, a lot of local governments, when the rating system was devised in the 60s, began to think, this is such a fine idea, we should make it compulsory. As a matter of fact, there was one case involving a sheriff in North Carolina that thought that the rating system was such a dandy idea that he was going to prohibit any drive-in theater in his jurisdiction from showing anything above a G rating. So fortunately, the courts have always made short work of those kinds of rating systems.
Free market would have taken care of his drive-through too.
Yeah. They have, exactly. They have always been struck down, and I think any time you combine sort of an official imprimatur with a private editorial system or rating system, then you're going to have a constitutional issue.
We are about out of time. I want to thank our guests, Robert Corn-Revere, First Amendment attorney, Pete Tucker of thefightback.org. And Pete may not agree with everybody in this room, but if you visit his website, you can see what's being done with real street-level journalism on the website, and it is a great example of how the internet can be used to do reporting that is not reported in the mainstream media. So thanks for your attendance. Thanks for you online. Thank you to our guests.
Thank you.
Thank you.